Used. You have been saying in the last 24 hours on your radio show, and you told me privately, that this very well violates our Constitution and more specifically the Appointments Clause. And I want you to really explain this to our audience tonight.
First of all, this seed was planted with me by hat-tipped Professor Stephen Calabrese, an old friend of mine who worked for Attorney General Meese as well. We have in the Constitution something called the Appointments Clause. And it applies to principal officers of the executive branch. There's inferior officers, like a chief of staff, an administrative assistant who reports to a principal. Then there's principal officers. As an example, every single United States attorney in the United States has to be nominated by the President of the United States and confirmed by the Senate, because our founders made clear that they wanted both branches of government involved in appointments of these senior level people. You have assistant secretaries in departments, deputy secretaries in departments, and of course cabinet secretaries, and I said U.S. attorneys. Here's the problem. The appointment of Mueller is utterly unconstitutional for a number of reasons. Rod Rosenstein gave him an agenda that is so broad, not a specific individual, not a specific statute, not even a specific matter. And not only was the initial appointment incredibly broad, he keeps expanding it. So this special counsel is different than past special counsels. He's more like a roving U.S. attorney. Also, we learned something today that's absolutely incredible. In Politico, it says several court filings indicate that when lawyers for Mueller's office appeared in federal court in Alexandria earlier this year, they did so not only as representatives of Mueller's office, but they received an appointment, a special assistant United States attorney appointment in the Eastern District of Virginia. They are, in effect, assistant United States attorneys. Robert Mueller wanted to expand their power. They report to him. If they're assistant United States attorneys or special assistants United States attorneys, that makes Mueller, without question, the equivalent of a United States attorney. So what's unique about him and past independent counsel and special counsel is the massive breadth of his investigation. He's going into bank fraud, wire fraud. He's going into Russia. He's going into a number of other countries. He's interviewed hundreds of individuals, tens of thousands, hundreds of thousands of documents. He's not an inferior employee like an administrative assistant or anything of that sort. He is a principal officer. And under the Appointments Clause of the United States Constitution, Article 2, Mr. Rosenstein usurped the authority of the President of the United States to nominate whomever he wants as a prosecutor, and Mr. Rosenstein usurped the power of the United States Senate, which has the control over confirmation or not. Mr. Mueller is serving unconstitutionally in violation of the Appointments Clause of the Constitution because of the way Rosenstein appointed him, because of expanding his authority, because Mr. Mueller has expanded his own authority with these four now assistant United States attorneys. And every defendant in this case, every witness in this case, everybody who receives a subpoena in this case, whatever federal court it is, should raise the issue of the Appointments Clause of the Constitution and that Mr. Mueller is conducting himself and his appointment is unconstitutional. See, here's the deal. These career bureaucrat prosecutors like Rosenstein and Mueller and Comey, they don't understand the Constitution. They understand parts of it like due process, warrants, subpoenas, probable cause. They've never read the Appointments Clause. Well, they've never read the Supreme Court decisions involved in that, like Morrison versus Olson and so forth. I have. Professor Calabrese has. I want your audience to know this too. So Mr. Mueller, unlike any past special counsel, unlike any past independent counsel, the breadth of his investigation is so massive, it's so broad. By the initial appointment, the subsequent expansion, and now four of his own people getting dual appointments as effectively assistant United States attorneys, Mr. Mueller, his conduct, his appointment is unconstitutional.
You know, that's why I call you the Great One. What you're saying, I hope every attorney involved in this case heard you. And if you're out watching tonight, when this is up on foxnews.com, please tweet it out. Please use social media. Please make sure this goes viral.
And all you attorneys out there, go for it, baby. I know what I'm talking about.
And first, I want to give a significant hat tip to a very dear friend of mine. We worked together in the Meese Justice Department. He was special counsel, a real special counsel, not the Mueller type, to the Attorney General, Ed Meese, in the Reagan administration. I was chief of staff at the time. And he went on to be a superb law professor at Northwestern Law School. So over the weekend, he put together an opinion. Very well searched, 16, 17 pages, relevant footnotes, case law citations. And he said, look, let me lower this here. The appointment of Mueller, particularly Mueller, violates the Appointments Clause of the Constitution. It violates the Appointments Clause of the Constitution, which is in Article 2. Here in part is what he wrote to me. Robert Mueller has behaved like all the United States attorneys. They are principal officers of the United States. Principal officers, not inferior officers. We'll get to this distinction in a moment. It's crucial. All principal officers must be nominated by the President of the United States for consideration by the United States Senate, which will either reject or confirm. Mueller has not behaved like an assistant United States attorney who's an inferior officer and who may be appointed by a principal officer like a deputy attorney general like Rosenstein. Mueller's appointment is, therefore, unconstitutional. Under Chief Justice Rehnquist, the late Chief Justice Rehnquist, majority opinion in Morrison v. Olson back in 1988, because it takes away, quote-unquote, too much executive power from the president. In other words, the president doesn't even have the opportunity to nominate because Rosenstein essentially seized the presidential power to nominate a principal officer and cut out the Senate. It is unconstitutional because Mueller does not have a boss who is supervising and directing what he's doing. So he's not an inferior officer. You know, the bureaucracy is filled with inferior officers. That is, we're not saying they're inferior human beings, inferior as opposed to principals. Principals are required to get Senate confirmation. Inferior appointees are not. We have a bureaucracy with 2 million people. The overwhelming majority, the vast majority, are considered inferior. They're not presidential appointments. And in the case of the Deputy Attorney General, he has deliberately abstained from playing a significant, daily, regular management and oversight role over Mueller. In fact, he's basically a rubber stamp. The appointment of Mueller in the first instance was extraordinarily broad, but it's only got friend wrote to me. The Appointments Clause of Article 2, here's what it says. The President shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may, by law, vest the appointment of such inferior offices as they think proper in the President alone, and in the courts of law, and in the heads of departments. In other words, you have levels of these principal officers who are required to be nominated and confirmed by the Senate in order to hold these principal positions. And then you have all the rest who serve them. Principal officers are selected by the President with the advice and consent of the Senate. Inferior officers, Congress may allow to be appointed by the President alone, by the heads of departments, or by the judiciary. Let me give you a perfect example. The Department of Justice. Let's take the mothership, the Department of Justice. The Attorney General of the United States is a principal officer. In order to serve in that position, you must be nominated by the President and confirmed by the Senate. The Deputy Attorney General of the United States, the lower next level, must be nominated by the President and confirmed by the Senate. The Associate Attorney General of the United States, the number 3 down, must be nominated by the President and confirmed by the Senate. Then you have a number of Assistant Attorneys General for antitrust, for civil rights, and so forth and so on. Even they are considered principal officers. They can only serve in those positions if they are nominated by the President of the United States and confirmed by the Senate. Every single United States attorney in this country has to be nominated by the President of the United States and confirmed by the Senate, not assistant U.S. attorneys, line attorneys, and so forth, because their day-to-day activity is managed by the United States attorney. The United States attorney. But they have a number of assistant attorneys general, depending on the size of the office, many. And they, of course, are not principal officers. They do not need to be nominated. So is Mr. Mueller more like an assistant U.S. attorney or more like a United States attorney? Is there a United States attorney in the country more powerful than Mr. Mueller? Not one. Particularly under the so-called management of Rod Rosenstein, which is nearly non-existent. It has been long-standing practice of Congress and the executive branch to give principal officers a status to all important and powerful public officials, even if they have a boss who can fire them. So, cabinet secretaries have always been treated as being principal officers, even though they can be fired by the president. Deputy and assistant cabinet secretaries, all of whom must be nominated and confirmed by the Senate, are also principal officers, even though they can be fired by the cabinet secretary they report to as well as the president. But their jobs are considered important. So it's unthinkable, for example, he writes, that the deputy secretaries of state or of defense or of this Department of Justice could be made an inferior officer on the say-so of their bosses. These officials simply exercise too much power to be denominated inferior officers. They are instead principal officers who must be nominated by the president and confirmed by the Senate. That's your appointments clause. Even the federal judiciary. We find that federal court of appeals judges and federal district judges have always been treated as being principal officers, even though their decisions can be overruled by the Supreme Court. No one thinks, or should think, that Congress could vest in the Supreme Court the power to appoint lower court judges or inferior judges. It's obvious that lower federal court judges must be principal officers nominated by the president and confirmed by the Senate, even though their very existence isn't even in the Constitution. And it's obvious that Robert Mueller is behaving much more like a U.S. attorney than he is behaving like an assistant U.S. attorney. Mueller has acted and has behaved like a principal officer, even though he was never nominated by the president or confirmed by the Senate. Now, I've said that 5 times because it's important. The text of the Appointments Clause in your Constitution and the use of the word inferior elsewhere in the Constitution makes it clear, says Calabresi, that there are 2 prerequisites that must be met for someone to be an inferior officer and therefore not subject to nomination or confirmation. First, one must have a boss who the inferior officer reports to who can direct or fire the inferior officer. Okay, fine. The second, an office cannot be inferior if the officer exercises as much power as is exercised by every United States attorney and even more, and the deputy and assistant cabinet secretaries, or even more. This second test as to officer inferiority is somewhat subjective in close cases, but it's very real nonetheless. If a prosecutor has as much power as a U.S. attorney, he's by definition a principal officer of the United States who must be nominated by the president, confirmed by the Senate. Now, obviously, there are differences. In some ways, the U.S. attorney is more powerful in terms of the breadth of what he can investigate, or she. But in some ways, Mr. Mueller's more powerful in the nature of who he is investigating and how he's investigating them. So the issue isn't an exact parallel. For instance, a U.S. attorney has to be nominated and confirmed. An assistant secretary of agriculture has to be nominated and confirmed. The point is the breadth of their power that they exercise and the impact of that power, and whether or not they are truly effectively under the management control of somebody else. And even so, it depends on what kind of control we're talking about. An assistant secretary of agriculture reports to the deputy assistant secretary of agriculture, who reports to the secretary of agriculture. So it's understood that we're not just talking about the heads of a department, the heads of an agency, or in the case of a U.S. attorney, the heads of an office. Is there any question about Mr. Mueller's power? Justice Scalia, Professor Calabresi points out, summarizes the history of the Appointments Clause in Edmund versus United States from 1997. He said, as we recognized in Buckley versus Vallejo, that was a free speech campaign contribution case in 1976. The Appointments Clause of Article 2 is more than a matter of etiquette or protocol. It is among the significant structural safeguards of the constitutional scheme. By vesting the president with the exclusive power to select the principal non-inferior officers of the United States. The president, not the deputy attorney general, the president. The Appointments Clause prevents congressional encroachment upon the executive and judicial branches. This disposition, this is Scalia, was also designed to assure a higher quality of appointments. The framers anticipated that the president would be less vulnerable to interest group pressure and personal favoritism than would a collective body. Hamilton wrote in Federalist 76, the sole and undivided responsibility of one man will naturally beget a livelier sense of duty and a more exact regard to reputation. The president's power to select principal officers of the United States was not left unguarded. Of course, under Article 2, it further requires the advice and consent of the Senate. This serves both to curb the executive abuses of the appointment power and to promote a judicious choice of persons for filling the offices of the Union. So the appointment of Mueller, in my view, and Calabresi's view, fails on two fronts. Number one, the Deputy Attorney General doesn't get to make an appointment of a man that's so powerful, of a public official, and therefore usurp the power of the president. Only the president can nominate such a person. And number two, it undermines the power and the role of the Senate under our Constitution because they get a bite at the apple, too. They get to determine whether or not that official should serve or not. And this is why it is amazing to see senators, Republicans, running to vote to protect Mueller. They do not even understand the Department of Justice memoranda when it comes to you cannot indict a sitting president, yet they want to protect the man. They do not understand separation of powers and the Appointments Clause. And these are people, you're lawmakers.